to be speaking to you today, giving you a little bit of a whistle-stop tour of the most recent changes and developments in homelessness law. We've got quite a bit to get through. I got quite excited because so much has happened in the last year. So we're going to be looking at, first of all, the changes that have been brought in by the Renters' Rights Act, before then turning to look at some of the developments in case law, particularly intentional homelessness, housing needs assessments, and then suitability, all of which have had some treatment that's quite interesting, certainly in my view, over the last year or so. So turning first of all to the Renters' Rights Act. The changes from the Renters' Rights Act are vast, and it's because it's such a landmark piece of legislation. The core purpose of that legislation from the outset has been to provide greater security, stability, and higher quality housing to people. So the natural knock-on effect of that is that it's going to affect homelessness law, because previously it's insecure tenancies and arbitrary evictions that have been the leading cause of homelessness. The changes are in force from the 1st of May, but there are some transitionary stages to be gone through. So looking at some of the key changes, I think one of the primary ones that's going to be interesting to see the effect of is the changes to the legal definition of what threatened with homelessness means. And that's because that legal definition is vital as a trigger mechanism for the legal rights that are going to be owed by local housing authorities. It's primarily whether or not a person meets the 56-day threshold in terms of whether they have a housing problem. And that will trigger what's known as the prevention duty, which is the requirement to take reasonable steps to help an applicant to keep their current home or to find alternative accommodation. Now, the difference that the Renters' Rights Act has brought in is that previously it was service of a Section 21 notice that triggered that duty that followed from the threatened with homelessness definition. Now, because of course we've gotten rid of Section 21 by and large, Section 8 is what's going to trigger this. And Section 8, whether or not it's Section 8 served on a mandatory or a discretionary ground. And it's that point that, certainly for my part, I find quite interesting, and I'm quite interested to see what's going to happen as a result of that. Because what it's likely to mean is that, in effect, everybody that gets a Section 8 notice will be owed those duties under Part 7 of the homelessness legislation. So that's the duty, the prevent duty that I've just mentioned, and also the Section 189A duty to assess a housing need and develop a personalised housing plan. What that means is that the reality is that the cases that come in as homeless applications are going to become a lot more complicated, because it's not just going to be, right, has a Section 21 been served or not, and have they met the prescribed information requirements? It's going to be looking behind what's going on there, because of the fact discretionary grounds are being used as well. It's going to be looking at in fault. So it's going to open up all of those questions around intentional homelessness, in short, which I think it's going to depend on how successful this piece of legislation ultimately is in stemming the flow of notices seeking possession, as to whether that actually happens. Now, as I've mentioned, there is a transitionary period in terms of when Section 8 is going to be what triggers the threatened, a Section 8 notice is going to be what triggers the threatened with homelessness definition. And so at the moment, if somebody comes in and they've got a Section 8 notice that was served before the 1st of May, it's not going to be automatic that they're going to fit the threatened with homelessness criteria, but that's going to turn on the facts of the case. And ultimately what that's going to come down to in reality is how likely they are to be found homeless, which is quite a finely balanced point. But if for those of you who work with homeless applicants, and also those of you who are seeing these applications, you get a Section 8 notice that's predated 1st of May, that's going to have to be assessed. How likely is this person going to be made homeless, based on the facts of the case, based on whether this notice is on a mandatory or a discretionary ground. The next change that's linked to that change then is that Section 8 notices and what makes a valid Section 8 notice has been tweaked by the Renters' Rights Act. So from the 1st of May, private landlords must make sure that any Section 8 notice is on the new prescribed Form 3A and that it references the new or amended grounds of possession. Now, there are 37 grounds at the moment under the with the amended grounds under which a Section 8 can be served. I'm not going to go through all of them, but a couple that I did want to mention that I think are certainly interesting for us working in this field are, of course, the changes to Ground 8 that I'm sure many of you will be aware of, in that the threshold for rent arrears has been increased and the notice period for those notices has been increased. Again, when we're looking at these changes that the Renters' Right Act has brought in, I think it's really important, and what helps make sense of them is to think about what the aims of that bill were, and it's to try and give people security of tenure. So that's why you've got effectively more leniency for a tenant in terms of how high that rent arrears threshold has to be and how long they've got once a notice is served. The other new ground is that I think is quite interesting, and I'll be interested to see how it affects our work, is ground 5G, which is a ground that's been introduced where property is being used by a local housing authority to provide temporary accommodation to a homeless person. And the council or the local housing authority then notify that landlord that the accommodation is no longer needed because effectively that duty, whatever duty they were providing or decision they were providing, that temporary accommodation under has come to an end. So that's now got a whole new ground of its own. The thing to remember here, of course, is that Section 8 doesn't come with any prescribed information. So I'll say again, in my view, numbers of people who apply with a notice are going to go up. Of the applications that a local housing authority sees, more than likely a larger majority of them are going to meet that threatened with homelessness definition. Whether that means that overall the numbers go up now we've gotten rid of Section 21 might be a different question, but in terms of percentage of the applications that come in, I would certainly imagine a higher percentage will meet the definition. And then some other changes that I wanted to draw your attention to. The first is the ending of homelessness duties and how that's done. So from the 1st of May, there are amendments to Section 193 of the Housing Act that mean that the main housing duty, which can be ended with a private rented sector offer, can only be done where an assured periodic tenancy is given, not an assured short-hold tenancy. And that's, of course, because ASTs have been abolished. But something to be aware of, because as much as Renters' Right Act might have been top of our minds and something that all of us have been seeing on the horizon for a long time and preparing for, private landlords may not have been. So I would watch what you're getting in from them in that regard. An interesting development, again, which it seems linked to this idea that what the Renters' Right Act has done is provide more security of tenure, is the removal of the right to reapply. So previously, Section 195A of the Housing Act meant that where someone reapplied as homeless within 2 years of an offer of private rented accommodation, they were automatically found to be owed the main housing duty regardless of priority need. That's been removed, and why that's been removed is really to ensure that there's no longer a differential treatment between applicants who have their homeless duty met through private renting versus via social housing. And it's in that way that this is really trying to come from a position that, well, look, we've made private renting much more secure now, so it's almost on an equal footing with social housing. Or certainly that seems to be the rationale. And then the final change I wanted to discuss is the previous impact that a refusal to cooperate with a step identified in a personal housing plan has. So previously, if there was a deliberate and unreasonable refusal to take a step that was identified in a housing plan, it could mean that the main housing duty was ended. But Section 193C of the Housing Act has been amended so that subsections 3 to 10 have been removed. If you look at the legislation now, there are just little dots where those sections used to be. And so again, it's trying to provide that additional security of tenure to those people to make sure that if they are meeting the main housing duty criteria, it's not taken away from them. Now, I'm going to move on to talking about some of the most recent case law. And I wanted to focus on this case because I find it really interesting, this little area, and I'm sure it's one that all of you will have come across before. And it's within the definition of intentional homelessness and mental health. And certainly when looking at intentional homelessness, it's on this basis that the majority of the cases I've seen have been pleaded. This idea that effectively the person or the applicant isn't intentionally homeless, and it's because they haven't acted deliberately, and that's because they've been suffering from whatever mental health condition they have. Now, this case law has gone some way to clarifying the position in relation to that. So it's section 1911 of the Housing Act that provides that for homelessness to be intentional, the act that led to accommodation must be deliberate. But what that means is expanded on in paragraph 9.17 of the homelessness guidance. And there are, I would suggest, 3 key words there to focus on when we're looking at mental health as something that impacts intentionality. The first word is incapable, which I would suggest that's quite a high threshold. So it's incapable of managing their affairs. The second word, limited mental capacity being the key word there. And then we come on to, or a temporary aberration or aberrations. Now, I'll confess, all of you might have much better English than I do, but I've not heard the word aberration in any context other than this one. But I've had to look it up as to its definition many times, because it's that section that this often is hinging on, because it's not often that we're getting somebody who's being found intentionally homeless and they're completely incapable of managing their affairs, or they are of limited capacity. It's often this aberration point that's the hinge point in the applications. And an aberration, I'm told by Merriam-Webster, is something such as a problem or type of behaviour that is unusual or unexpected. So in this context, what it means is that the person has behaved in an unusual or unexpected way because of their mental illness, frailty, or an assessed substance use problem. That definition, and all 3 of those sort of key sections of it that I've taken us to, was considered by the Court of Appeal in the case of Bissandra. And it has quite interesting facts. It was an appeal to the Court of Appeal from a successful 204 appeal. So homeless applicants put in a section 204, succeeded, and the council have then taken this to the Court of Appeal to challenge it. The facts of the case are these. Mr. Bissandra had a really long history of mental illness, and he had multiple serious diagnoses. It included depression, anxiety, PTSD, and obsessive compulsive traits. In December of 2015, he voluntarily served notice to quit on a tenancy he had in the London area. And he asserted at the time that he put that notice in that it's because of ASB that was happening in the block he lived in. So he'd said that, but effectively he'd just handed his notice in. 2020 comes around and he applies again to the council, asserting that he's homeless, but they find him intentionally homeless because of that previous action of handing in the notice to quit. The Court of Appeal have dealt with this, and I have included the full paragraph 56, which is the key part for our purpose when we're looking at what deliberate act means in relation to mental health. And what they say is that, and I'm reading out the key parts, I've not been persuaded that for mental illness to render an act or omission non-deliberate, the person must have lacked mental capacity. Neither, however, do I accept Miss Davies' submission that it suffices that a mental health problem played a significant role in the relevant act or omission. What the Court of Appeal have done is give us some parameters to work within in terms of what we're looking for if somebody's asserting that it's because of their mental health that they've done this deliberate act. It doesn't have to be that they've lacked capacity, but that a significant role's not good enough either. We've got a lot of grey area in the middle there, and in my view, this is a matter that needs further clarification, at least to some extent. What they say, they go on to say in that paragraph in terms of justifying that position is that they don't want anyone who chooses not to pay rent because of a mild depression to be able to say, well, it was my mental health that caused it. That doesn't, in my opinion, explain the position in relation to someone with as serious a set of conditions as Mr. Bissandra had in this case. overall, my takeaways from that case are that the threshold has, at least to some extent, been heightened. It's clear that because if we take aberration to mean its ordinary thing, which is a temporary, unusual behaviour, it's clear that something much more than that, or at least slightly more than that, is going to be needed, because a significant role is not enough. It's my view, however, that there's still room for argument on it. We have got that grey area. So while there's some parameters, there's this grey area in the middle. And I'm in the middle of, awaiting a decision from the Court of Appeal at the moment on whether they'll be willing to accept an appeal on this point, where I'm acting for a homeless applicant who's had a hoarding problem. And as you can imagine, she's been found intentionally homeless because of her hoarding. But what I, on her behalf, I'm seeking to argue is that that hoarding behaviour is linked to a whole series of both physical and mental health diagnoses that she has. So I'll let you know next year how far we've gotten along with that one. But I want to go on to talk about housing needs assessments, because there have been 4 really interesting cases that have come out in the last year or so in relation to that. Now, generally, where a local authority is satisfied that a homeless applicant is eligible and either homeless or threatened with homeless, it must assess their needs and it must provide a personal housing plan based upon that assessment of need. Now, the first case I want to take you to is AN and London Borough of Barking and Dagenham. That's a High Court case where the council hadn't properly considered the educational needs of a disabled child that was part of the housing application, and that was despite them being given the relevant information from multiple sources, the applicant and her solicitor, as well as professionals involved with the family, who'd made it quite clear that because the child had a diagnosis of autistic spectrum disorder and special educational needs, there were additional things to consider in terms of meeting those needs and education, particularly whether this child was going to be able to take long journeys to and from school, as an out-of-district placement was being considered. What I think seems to have been the real sort of final nail in the coffin here for the council is that there had been 4 attempts at completing a housing needs assessment. And none of them had taken proper account of those additional needs that the child had. And of course, the challenge was brought not only on the basis that there's a duty to complete this assessment, but also if that's not done properly, it brings into play the Children Act, Section 11 in this case, but Section 17 could also be relevant on different facts, and the public sector equality duty, because of course the child's disability hadn't been properly considered. Now, the key passage, certainly I would say is the key passage, is where the court find that hedging between needs and desires deprives the housing needs assessment of its purported functions. So from that, what I think we can take is that if you've got a housing needs assessment that isn't quite delineating between what is something that would be good or preferable, a want, and what is something that is needed because of a medical need or some other need that is evidenced, you're going to be in tricky water. And I think the court have particularly, what they're saying is that that's particularly problematic because the whole point of doing these housing needs assessments is to clearly demarcate between what's a want and what would be quite nice and what is actually something that's an evidenced need. But at paragraph 59 of the judgment, they give a full summary of all of the relevant principles related to doing these housing needs assessments. So that's not only what's come out of the legislation itself and the legislative principles and those in the guidance, it's actually a sort of roundup of all the relevant case law. The next case is the case of MKM. It's similar to some extent in terms of how the court have treated it. In this case, the applicant had a traumatic history after being a repeated victim of sex trafficking. She'd been living in London and they were considering an out-of-borough residence for her, specifically in Durham. Now, I'll pause there, particularly for those of you who are based in the North East. I don't know how many of you have seen this already, but I've been seeing it now since before I even did this job when I was working based with the police. London councils, particularly it tends to be, seeking to place in the North East, again, particularly it seems to be, County Durham and Teesside being what I've seen the most, It's something that there's getting to be more and more case law on now in terms of whether that's something that's okay, and generally it's found not to be. But what I'd say is acting quickly is key, because what I've seen when that doesn't happen is that you might then have 2 years before it's properly dealt with, or a year, where the family are in interim accommodation and then it becomes permanent accommodation in that area. And by the time they've been there for 2 years, the weight of the arguments to say, well, they should be in London where they started, have often reduced. Coming back to this case, and related to that point, the court were looking at the suitability of an offered interim accommodation in Durham and decided to look at that in spite of the fact that this appeal could have gone ahead on Section 202. And it's for that very reason that they did that. They didn't want this woman to have to move to Durham, stay there, go through the whole 202 and 204 process, potentially be there for many months. And by that point, in effect, the damage is done. And so I think that's a really key and interesting part of the judgment. Whether it's something that we'll see again, I'm not sure, but certainly something worth bearing in mind for those of you who are seeing these sort of applications like this, that if it's warranted, a JR might be the way forward to get a swifter response. It comes down to the same point in this MKM case, which is that distinction between what is a want and what is a need. And here, the need hadn't been taken account of. Moving on to the next case, and it's the case of Norton, and this is the Court of Appeal case. In that case, there hadn't been a housing needs assessment. An offer of suitable accommodation was made. There was no challenge to the suitability of that accommodation, but the applicant tried to challenge it by saying, well, you haven't done this assessment. And what the court said clearly is effectively no, because there's no way that Parliament could possibly have intended that a suitable accommodation would be refused just because we haven't effectively done this administrative task. That cannot be what's meant. It links, in my view, to what's generally known as the no substantial difference test that we see a lot in judicial review and in public law arguments generally. And that's set out in Section 31(2)A of the Senior Courts Act, and something worth knowing anyway, which is effectively, even if you can point to, or an applicant can point to, something that's been done wrong or not been done at all, and they can point it out clear as day, as in this case, to say, look, you're meant to do this assessment and you haven't. It's not a grey area. They are meant to do it and they definitely hadn't. If that is in effect not going to make a difference to the outcome, then the court's not going to bother doing anything about it. And that no substantial difference test, I would say, is one to have on your books generally. If you're somebody that's defending public law proceedings in general. Now, the next case, Fatolazadeh, it's in the similar vein. In effect, hollow legalistic arguments about whether there had been a failure to comply with the housing needs assessment duty were dismissed. And it's because they weren't going to make a difference. It's that same point again, and that's why I'm emphasising that need to have a look at. It's not just whether there's been a breach of some sort of rule or duty, it's what impact that's actually had, and if you can point to an impact that it's had. The other thing that's mentioned in that case as a reason why there wasn't a progression of that point is that there hadn't been a previous challenge of the lack of the Section 189A. And I raise that for those who are dealing with applicants, because it might be, I think a lot of the time the temptation can be to wait until there is an offer of suitable accommodation or of accommodation and to bring a suitability challenge. If someone is coming to you at that earlier stage where they've had an assessment done and you're seeing an assessment that it's bullet points, it doesn't deal with their extreme vulnerabilities, medical needs, etc., think about whether a judicial review might be appropriate at that stage rather than waiting and seeing what happens next. Because otherwise, as here, it may be that it's taken to be too late. Now, coming on just a couple more cases to look at, and they're on suitability. The case of Hamad is a High Court case. And I've picked this one out because I think it's interesting, particularly for those who work in this sector from local authorities, who often in these cases, and I'm sure those who work with applicants have had some frustration with this in the past, where public law arguments are made, whether it's a suitability challenge or other form of judicial review challenge, and at the last minute the local authority will go, actually, yeah, we accept the breach. Now, in this case, that had happened. it was agreed that there'd been a failure to meet the duty to provide suitable temporary accommodation, and that was agreed by the time they got to the doors of the High Court. And so what the local authority was saying is, well, you don't need to make a mandatory order for us to provide that suitable accommodation. We already accept that we didn't do it before. We're going to sort it out. Give us a bit of time. They hadn't, however, provided any evidence of what steps they'd been taking, what steps they were intending to take, what was going to happen next. In other words, they hadn't shown the word working out. They'd just gone, oh yeah, we accept it, we admit it, and thought that was enough. And it wasn't. The court have made a mandatory order and made it with quite a strict deadline because they weren't persuaded. So for those of you who are working for local authorities, if those things are done, and often it can be sensible to accept a breach if there has been one, it's important that that follow-up work is then done to either take the steps or at least set out what steps are going to be taken. And finally, Enfield, it comes back again, in my view, to this idea that unless there's a material impact on an applicant, very little is going to be done by the court. They want to know if it's actually going to make a difference. It's not a case of, well, you've just failed to meet this duty. And in that case, there is a duty if you're placing somebody out of the district to notify the other local authority you're sending them to that you're doing that, and that hadn't been done here. Again, very clear breach. There wasn't an argument that it might have been done. They're meant to do it, they hadn't done it, but the court refused to intervene on the basis and didn't take any further steps on the basis that it hadn't made a difference. This applicant couldn't point to what difference it had made to them at all.